Welcome everyone to today's webinar. While we're waiting for a few more to sign up. Right, thank you for joining today's webinar. What makes an offence an economic crime? I'm so glad you could all make it, and wonderful to see participants from so many parts of from different parts of the world. It's great to have you join us today. This has really become a hot topic over the last few years. Trust me, this is not one of the boring ones where you'll be wanting to sort your inbox at the same time. This one is riveting and you'll want to pay attention. So 2 points before we continue. If you have any questions during the PowerPoint, there is a Q&A button at the top of the screen. Click the button at the, and you can type in your questions. We shall try our very best to get through all the questions, time permitting, at the end of the presentation. If you would like your question to be anonymous, there is a small box in the left-hand corner. You can tick it and your questions will become anonymous. There will also be a quick evaluation form on the chat group. Please take a moment to fill it out. It really does give us the information to help give you the content that you want to see. So please do take a few moments. We can send it out by email too. For those that may not know us well, FB Attorneys is a corporate and commercial law firm based out of Tanzania. We also publish the very popular Q&A and legal updates. For those of you who are not subscribed already to our publications, you can visit the publications page on our website to subscribe, or you can simply send us an email. Our presenter today is Timon Vitalis, Head of Litigation at FB Attorneys. We are privileged to have him with us. A former prosecutor with over 20 years of experience in criminal law, and as well as graduating here in Tanzania, he has also studied and researched in the UK, US, and South Africa. So without further ado, I will set up the presentation. And let's hope this works. Please bear with me.
Thank you, Faizin. You are all welcome on our webinar on what makes an offense an economic crime in Tanzania. The first slide you see there is an overview of what my presentation is going to cover. My presentation is going to cover the history, the legislative history of economic crime legislation in Tanzania, the salient features of Economic and Organized Crime Control Act, what conduct is considered an economic crime in Tanzania, examples of economic offenses, bail in economic offenses, case law on bail, trial of economic cases, effects of being charged with an economic offenses, and finally questions and answers. Now, to start with the legislative history of economic crime law in Tanzania, as we shall see, the history is a bit sour. I'm saying the legislative history of economic crime law is a bit sour because it, as we shall see, it is tainted with the denial of basic human rights such as right to bail, right to appeal, and right to timely justice, among others. The history, the legislative history of economic crime legislation in Tanzania starts way back in early 1980s. In early 1980s, Tanzania experienced acute shortage of consumer goods. It is said the cause of this acute shortage of consumer goods was, among other things, the war with Uganda in 1978 to 79 and the drought in 1979. There were so many other causes. As a result of these three things, the drought and the war, the production went low. As a result, there was a growth rate also decreased from 6% in 1967 to negative 2.4 in 1983. The inflation also went high, up to 30%. Initially, the government started taking measures by addressing this problem addressing the problem by taking legal action against those who are suspected to have been taking the advantage of the situation by hoarding goods, hoarding money, manipulating foreign exchange, and doing other things that were equally causing the situation to be more worse. Now, this did not effectively address the situation. I'm saying did not effectively address the situation because the government thought the use of regulatory laws that were in place at that time and the penal code could not effectively address the crimes committed by those who are taking the advantage of the economic situation at the moment. So what the government did then, it started using the Preventive Detention Act. By detaining the suspected saboteurs in prison without trial, the president was given power and had power under the Preventive Detention Act to detain someone without a trial. So the president used his power under the Preventive Detention Act to order the arrest and the detention of the suspected saboteurs without trial. But this was criticized because it was against human rights. So the government then took another action through the parliament by enacting the Economic Sabotage Special Provision Act number 9 of 1983. This was a specific legislation meant to address the economic sabotage crime at that time. The act came into force on 4th of May 1983. But surprisingly or strangely, this act was given a retrospective effect in the sense that it was used backward to charge and prosecute offenders who allegedly committed economic sabotage crimes before the act itself came into force. So it was given a retrospective effect up to 25th of March 1983. The Economic Sabotage Act was as such meant to be an interim law. An interim law was meant to be a temporary law for only 12 months. But the president was given power by the legislature under the Economic Sabotage Act to extend the application of that law for 6 months, meaning the law was intended to be enforced for only 18 months. After the expiration of 18 months, the law required the further extension to be made by the parliament. So after the expiration of the time set by the parliament for enforcement of the Economic Sabotage Act, then in 1983, within the same 2 months only after the Economic Sabotage Act number 9 of 1983 came into force, it was amended. It was amended by Act number 10 of 1983. Only 2 months. Now, what changes were brought by Act number 10 of 1983? If you compare Act number 9 of 1983 and then number 10 of 1983, under the Economic Sabotage Act number 9 of 1983, the president was given power to admit the accused to bail. So power to admit the accused to bail was given to the president and not to the National Anti-Economic Sabotage Crime Tribunal, which was a tribunal specifically established for the economic sabotage crimes. So you can see here, the power to admit someone to bail was given to the executive arm of the state and not to the special tribunal that was established specifically to deal with economic sabotage crimes. But the other thing you can see, another difference you can see between Act number 9 and Act number 10 is that under Act number 9 of 1983, there was a right to appeal to the president to challenge the sentence and not the conviction. So once the tribunal convicted someone of an economic sabotage crime, there was no right to appeal. the convict could only appeal to the president to challenge the sentence and not the conviction. But now, after the amendment of the Act by Act number 10 of 1983, even the right to appeal to the president was also curtailed. So there was no further right to appeal to the president. And the other thing, which is important to note, there was no right to a legal representation. Advocates were not allowed to appear in court to represent those who are suspected of having committed the economic sabotage crimes. This tribunal, the National Anti-Economic Sabotage Tribunal, was presided over by a judge who is a trained lawyer with 2 lay members. But strangely, an advocate was not allowed to appear before a trained judge. What you can also see, this the Economic Sabotage Act had few offenses listed in the first schedule as economic sabotage crimes. It had only 8 items mentioning what amounts to economic sabotage crimes at that time. But the president was given power under the Economic Sabotage Act to declare by order published in the Gazette that from this date, this conduct will also be part of the economic sabotage crimes. Meaning what? The president had power now to create an offense or to make a conduct which was not an economic offense to become an economic sabotage crime. This act is then in 1984, after the expiration of the time given for the Economic Sabotage Act in 1984, there was a repeal of the Economic Sabotage Act and a substitution of the Economic Sabotage Act by the law which we now have called the Economic and Organized Crime Control Act, popularly known as the Hujumu Uchumi Act. Okay, as I said, the Economic Sabotage Act established the National Anti-Economic Sabotage Tribunal, and it gave the tribunal exclusive jurisdiction over economic sabotage crimes. The after the enactment of the Economic and Organized Crime Control Act, there were changes made regarding the adjudication of the economic sabotage offenses in Tanzania. The Economic Sabotage Act established the tribunal, but the Economic and Organized Crime Control Act gave the adjudication power of economic crimes to the High Court, sitting as Economic Crime Court. So this is where you get the difference. The National Anti-Economic Sabotage Tribunal was a permanent tribunal established by the law, but the Economic Crime Court was actually a high court sitting as, it was a high court occasionally sitting as the Economic Crime Court. So it was a high court as such. It was not a special tribunal. But still, even under the Economic and Organized Crime Control Act, which established the Economic Crime Court, members of the Economic Crime Court were selected by the Judicial Board, as opposed to the National Anti-Economic Sabotage Tribunal, whose members were appointed by the president. So that is another difference you can see. And some other changes you can see between these two laws is that under the Economic and Organized Crime Control Act, bail was allowed, although it was allowed under some conditions and restrictions. There were restrictions to bail, but at least it was allowed in some circumstances, unlike under the Economic Sabotage Act, where the bail was totally prohibited. Then, under the Economic and Organized Crime Control Act, which we still have now, there is a right to appeal, as opposed to Economic Sabotage Act, where there was no right to appeal at all. The other thing is you can see the president's power also disappeared under the Economic and Organized Crime Control Act. You don't see the president being mentioned anywhere. You can only see the minister being mentioned in Section 58 of the Economic and Organized Crime Control Act. The minister is mentioned there because the minister, Section 58 of the Economic and Organized Crime Control Act, gives the minister power to add the list of economic offenses in the first schedule after getting the approval of the National Assembly. But as we have seen under the Economic Sabotage Act, that power to add offenses, economic offenses in the list, in the schedule, was given to the president. So power of the president now were given to the minister. And in this case, minister is the Minister for Justice. But you can also see the Economic and Organized Crime Control Act was amended in 2016 by Act number 3 of 2016. Now, the law establishes the Economic Corruption and Economic Crime Division of the High Court. So now, the court that is charged with the duty to adjudicate the economic crimes in Tanzania is the Corruption and Economic Crime Division of the High Court, which is a branch, it's a division of the High Court. And the judge is now not needed or required by the law to sit with the lay members. So the judge can sit alone, and this is the only High Court conducting criminal trials without aid of assessors or lay members, unlike trial of other non-economic offenses that must be tried in the High Court with aid of assessors. This Economic Corruption and Economic Crime Division is permanent. It's a permanent division, unlike the High Court sitting as Economic Crime Court, which was a ad hoc court, constituted only when there was a need to try an economic offense. So those are the differences you can see between the changes brought about by Act number 3 of 2016. What makes an offense become an economic offense in Tanzania? Section 2 of the Economic and Organized Crime Control Act defines an economic offense as an offense triable under the Economic and Organized Crime Control Act. What are those offenses which are triable under the Economic and Organized Crime Control Act? Offenses triable under the Economic and Organized Crime Control Act are the following. One is the offenses created under the first schedule to the Economic and Organized Crime Control Act. The first schedule to the Economic and Organized Crime Control Act creates some of the economic offenses. And all those offenses created under the in the first schedule to the Economic and Organized Crime Control Act are regarded as economic offenses. The second category of economic offenses are offenses punishable under the Economic and Organized Crime Control Act by being listed in the first schedule to the Economic and Organized Crime Control Act. The first schedule to the Economic and Organized Crime Control Act contains some of the offenses that are not created under the schedule. They are created under other laws, but listed in the first schedule to the Economic and Organized Crime Control Act. Once an offense is listed in the first schedule to the Economic and Organized Crime Control Act, though not created there, it becomes an economic offense. The third category of economic offenses are offenses made economic by the DPP. I will explain how the DPP can make an offense economic. Section 12, subsection 4 of the Economic and Organized Crime Control Act gives the DPP power to institute non-economic offense in the Corruption and Economic Crime Division of the High Court. Essentially, the Corruption and Economic Crime Division of the High Court has power only to deal or try economic and corruption offenses. So when a non-corruption or a non-economic offense is charged in the Corruption and Economic Crime Division of the High Court, the DPP must give a certificate giving the High Court division power to try a non-economic offense. And once that power is given to the Corruption and Economic Crime Division of the High Court to try a non-economic offense, then such non-economic offense is deemed to be an economic because it is triable in accordance with the Economic and Organized Crime Control Act. The issue that arises from this is, in case the accused is found guilty by the Corruption and Economic Crime Division of the High Court, found guilty of this non-economic offense, what penalty will the Corruption and Economic Crime Division of the High Court impose? Will it impose penalty prescribed under the Economic and Organized Crime Control Act? Or will it impose the penalty provided for that offense under the act creating such offense? The law doesn't provide the answer to this, but my opinion is DPP only gives the High Court power to try a non-economic offense. The triability of a non-economic offense by the Corruption and Economic Crime Division of the High Court does not give that court power to impose a sentence provided under the Economic and Organized Crime Control Act. So in case the accused is found guilty of non-economic offense, tried under the Economic and Organized Crime Control Act, the sentence to be imposed shall be the sentence prescribed for that offense under the act that creates such offense. The other way of making an offense economic is all about the manner or the way the offense is committed. If an offense is committed in an organized manner, if an offense suggests that there was a criminal racket, the offender can be charged with the offense called leading organized crime. I'll give an example of stealing. Stealing or theft is not an economic offense, but if stealing is committed in an organized way, the offender may be charged not with stealing, but the offender may be charged with the offense called leading organized crime. Leading organized crime is listed in the item number 4 of the first schedule to the Economic and Organized Crime Control Act. So what the prosecutor will do here is not to charge stealing, because stealing is not an economic offense. He will charge the offender with leading organized crime, and by so doing, he makes the offense economic. And the penalty that the court will impose to the offender is not the penalty prescribed under the Penal Code for the offense of stealing. It will be a penalty provided under the Economic and Organized Crime Control Act, which is 20 years imprisonment, the minimum. Now, the other way of making an offense economic is by charging money laundering. How can money laundering make an offense economic? In the first place, money laundering is listed as one of the economic offenses. But money laundering as a secondary offense is normally associated with the primary offense, which is called the predicate offense. Section 3 of the Anti-Money Laundering Act contains a very long list of predicate offenses. For example, tax evasion is not listed in the first schedule to the Economic and Organized Crime Control Act as economic offense. But tax evasion is listed in the Anti-Money Laundering Act as a predicate offense. So if there is tax evasion committed, prosecutor may decide to charge 1, tax evasion, and 2, charge money laundering for the amount of tax evaded. So once money laundering is charged, the entire case becomes economic. Single offense in a charge sheet, single economic offense in a charge sheet, totally change the entire case to be an economic case. And it has to be tried in accordance with the procedure laid down in the Economic and Organized Crime Control Act, regardless of how many offenses are charged in the charge sheet. As long as there is one offense, which is economic offense, the entire case turns out to be an economic crime case. So that's another way of making an economic conduct an economic offense. Another way of making offense an economic is charging occasioning loss to a specified authority. Charging, how does charging offender with occasioning loss to a specified authority makes the offense economic? There are some conducts which may either be charged as occasioning loss or may be charged under other laws. I will give an example. I will repeat the same example of tax evasion. Tax evasion, as I've said, is not listed in the first schedule as an economic offense. But in a tax evasion, obviously, there is a loss of revenue to the government. So prosecutor may decide, instead of charging the offender under the Tax Administration Act for tax evasion, he can decide to charge the evaded tax as occasioning loss to the TRA. And once the offense is charged as occasioning loss to the TRA under the Economic and Organized Crime Control Act, the entire case changes to be economic. And even the penalty will be the penalty not that provided for tax evasion in the Tax Administration Act. Now, I will now take you through examples of economic offenses under the Economic and Organized Crime Control Act. The list below is not exhaustive. There are over 100 economic offenses listed in the first schedule. But the following are just the few examples we have pointed out. Giving false information to the Minister for Energy or PURA, this is Petroleum Upstream Regulatory Authority, in connection with an application under the Petroleum Act is an economic offense. So make sure when you are making an application to the Minister or to the PURA, you give the correct information. If the information given is found to be false, that will amount to an economic offense and it attracts a minimum of 20 years imprisonment. The reasonableness of making this offense economic is something that I cannot explain. That is the wisdom of the legislature. They decided to make it economic and it remains economic until the law is amended. Another example is withholding information with intent to deceive or mislead EWURA. So when EWURA needs information from you, make sure the information given to the EWURA is not misleading and you don't withhold information. Because withholding information or giving misleading information is an economic offense and it attracts 20 years imprisonment. Another example of economic offense is hindering, obstructing, restricting, or resisting an inspector or officer of EWURA to enter in or inspect premises or do search. What I want to explain here is obstructing even a police officer to discharge its duties is an offense, but not economic offense. But hindering or obstructing an officer from EWURA or inspector from EWURA is an economic offense, and it attracts a minimum of 20 years imprisonment. Why treating EWURAs differently from police officers who are essentially law enforcement agents, I don't know. But the other offense, which is economic, is refusal or delay or failure to comply with the order, prohibition, direction, demand, requirement, or notice lawfully made or saved, published. You can see how wide this law is. So if you get an invoice from EWURA, from PURA, to pay certain fee, delay to pay the fee, or failure to pay the fee, or refusal to pay the fee, amounts to an economic offense and is punishable under the Economic and Organized Crime Control Act. Another example of economic offense is fraudulent use of network to avoid payment. So those who abuse network, they are committing economic offenses. Another example of economic offense is unlawful interception of electronic communication. So any kind of, even if you are intercepting communication of your wife with someone or your husband with someone, that unlawful interception is an economic offense. Maybe you suspect your wife or your husband is cheating and you are intercepting the communication, then you are committing an economic offense. And the minimum sentence for it, mind you, is 20 years imprisonment. Another offense is interfering with functioning of computer system, unlawful possession or access to a computer password, sale of food which is unfit for human consumption. That's also an economic offense. So make sure the food you are selling is good and is fit for human consumption. If the food is unfit for human consumption, selling of it amounts to an economic offense. Sale or storage of food, medicine, cosmetics, or medical devices in the premises not registered with TMDA or TBS, that's also an economic offense. Some people sell medicines in unregistered premises. Some people sell food in unregistered premises, or store food or medicine or cosmetics or medical devices in unregistered premises. That is an economic offense. Hoarding commodities is an economic offense. Leading organized crime is also an economic offense. Fraudulent schemes is an economic offense. If you look at fraudulent scheme, it's similar to obtaining property or money by false pretenses. What I want to explain here, there are offenses in the first schedule to the Economic and Organized Crime Control Act, which are similar to offenses under the Penal Code. One of the examples of such offenses is fraudulent scheme. Fraudulent scheme is an offense listed, is an economic offense listed in the first schedule, but it is also an offense under the Penal Code. So it's the prosecutor's discretion to charge that conduct either under the Penal Code or under the Economic and Organized Crime Control Act. If the same conduct is charged under the Penal Code, it is an ordinary criminal case and it attracts a bit lenient sentence. But if same conduct is charged under the Economic and Organized Crime Control Act, it becomes an economic and it attracts a severe sentence, which is 20 years imprisonment, being a minimum sentence provided for it. Another offense is possession of goods suspected to have been stolen. This is also an offense which you find in the first schedule to the Economic and Organized Crime Control Act, but you also find it in the Penal Code. It is an economic offense if the value of the goods or the property is Tanzanian shillings 1 million, which is equivalent to about 420 US dollar. So if someone is found in possession of a property worth Tanzanian shillings 1 million, suspected to have been stolen or unlawfully acquired, prosecutor has two options. He can charge the suspect under the Economic and Organized Crime Control Act, or he can charge the offender or the suspect under the Penal Code. So the prosecutor's decision has something to do with the penalty to be imposed by the court and even the procedure to be adopted in prosecuting the offender. Another example which we have seen is occasioning loss to a specified authority and offenses related to uncustomed goods, interfering with the necessary services, using firearm to commit an offense other than robbery. So when firearm is used to commit an offense other than offense of robbery, assault, or other offenses, it becomes an economic offense. So it's the weapon used may also determine whether the offense committed is an economic offense or not. Another offense is unlawful prospecting. Theft of mail is also an economic offense. Hoarding of money, corruption offenses. When I'm talking about corruption offenses, are all offenses created under the Prevention and the Combating of Corruption Act, other than soliciting or receiving bribery contrary to Section 15 of the Prevention and the Combating of Corruption Act. I'll give you an example of false pretense to be PCCB officer. If someone pretends to be an officer from the Prevention and the Combating of Corruption Bureau, he commits an economic offense because false pretense to be a PCCB officer is one of the offenses under the Prevention and the Combating of Corruption Act, and for that matter, it is one of the economic offenses. If you pretend to be a police officer while you are not a police officer, it is an offense, but it's not an economic offense. But pretending to be a PCCB officer is an offense, and it is an economic offense which attracts a minimum of 20 years imprisonment. Other offenses that are economic are wildlife offenses, money laundering, terrorism, drug offenses, mining offenses, and something to let's now look at bail in economic offenses. Bail in economic offenses has sour history. I'm saying it has sour history because all along bail in economic offenses has been tainted with bail denials or bail curtailment. Under the Economic Sabotage Act, as we have seen, power to order the release of economic suspected saboteur was given to the president. So only the president could order the accused or the suspect to be released on bail pending trial of economic sabotage crime. Now, sometime later, 2 months after the enactment of the Economic Sabotage Act, Act number 10 of 1983 denied bail to the accused suspected of economic sabotage crime. So there was total bail denial by the law, that once you are charged with an economic sabotage crime, the accused is not entitled to bail. Under the Economic and Organized Crime Control Act, which came into force in 1984, bail was allowed, but we can still see restrictions to bail, which is sanctioned by the law. Under the Economic and Organized Crime Control Act, there are offenses that are bailable, and there are also offenses that are not bailable. And bailable offenses are basically three. Money laundering is unbailable. Drug trafficking is unbailable. Terrorism is unbailable. And all these three offenses are listed in the first schedule as economic offenses. But something to note is it is not the Economic and Organized Crime Control Act as such that impose restriction to bail for these offenses. This restriction to bail for these offenses is imposed by Section 148(5) of the Criminal Procedure Act. But since these offenses were now listed in the first schedule to the Economic and Organized Crime Control Act by Act number 3 of 2016, still they remain unbailable to date. Now let's look at the bailable offenses. Contrary to what many people believe, many people believe that once the offense charged is economic, then there is no right to bail. That's not true. Only the three offenses I've mentioned are unbailable economic offenses. The rest are bailable, although there are restrictions to bail imposed by the law. DPP may curtail right to bail of an economic offense by filing a certificate of bail denial in the court competent to admit the accused to bail. The DPP's power to disallow bail in economic offenses is provided under Section 36, subsection 2 of the Economic and Organized Crime Control Act. The DPP, when denying bail by certificate, is not required by the law to demonstrate or to justify why he is denying bail. All what is required to do is to say that for safety and the interest of the Republic, the accused should not be admitted to bail. It's not required to prove his assertion. So his mere assertion that public safety or interest is at stake is enough to deny bail. And it does not need to make that assertion in any kind of affidavit. It's a mere statement. Once certificate of bail denial is filed, then the accused will not be admitted to bail until the proceedings are concluded or the DPP decides to withdraw his certificate. Now, but bail can also be denied in other circumstances. Bail can be denied if the accused has been previously sentenced to imprisonment for a term of 3 years, or the accused has previously jumped court bail or breached the bail conditions, or if the accused is charged with economic offense while he is out on bail. So under those circumstances, the accused can be denied bail as well. The rest, apart from those unbailable, 3 unbailable economic offenses, the rest are bailable, but the bailability also depends on the value of the property involved and the stage at which the proceedings are. If the offense charged involves a property, and the property involved is worth 10 million or more, then the magistrate court cannot admit the accused to bail. He cannot, or she cannot admit the accused to bail. But if the value of the property involved is less than 10 million, the magistrate court can admit the accused to bail. This means what? In which court the accused has to petition for bail depends on the value of the property involved in the charge. If at all the offense charged involves property and the property has value. So if the property has value and the value of the property involved is 10 million or more, the accused has to petition for bail to the High Court. Even where the DPP gives the magistrate power to try an economic offense. Still, the value test is used to determine whether the magistrate or the magistrate's court can admit the accused to bail or not. What I mean here is the DPP is given power under Section 12 of Section 12 sub 3 of the Economic and Organized Crime Control Act to admit the accused, to give jurisdiction to the magistrate's court to try an economic offense. Ordinarily, economic offenses are triable by the Corruption and Economic Crime Division of the High Court. But the DPP is given power to confer a magistrate court, district court, or resident magistrate court with the power to try an economic offense. But even when the DPP gives such power to the magistrate's court to try an economic offense, that magistrate court cannot admit the accused to bail simply because the offense charged involves property and the property involved is worth 10 million or more. We have the case example of DPP versus Annette John McCammon. This is a Court of Appeal decision where the Court of Appeal said the test whether the subordinate court can admit the accused to bail or not is the value of the property involved. So if the property involved, its value is 10 million or more, then the accused has to petition for bail to the High Court. Now, let us look into case law examples on bail in economic and organized crimes. In the case of DPP versus Lingling, the Court of Appeal ruled that the certificate of bail denial can be filed in the court at any time before the grant of bail. In another case of Emmanuel Symphorian Masawi, which is also a Court of Appeal decision, the Court of Appeal was of the view that DPP certificate of bail denial can be challenged if it is made in bad faith. That is to say, it is nullified. Despite this suggestion made by the Court of Appeal, there are still difficulties in challenging DPP certificate of bail denial. The following are the challenges. One, the law does not prescribe the form or mode of challenging DPP certificate of bail denial. Can it be challenged by way of judicial review, or can it be challenged by way of an application before the same court where a certificate of bail denial is filed? The answer is neither provided under the Economic and Organized Crime Control Act, nor is it provided by the case law in the case of Symphorian Masawi. So despite Court of Appeal having ruled that DPP certificate of bail denial can be challenged, still we don't have any case that has been so far filed in any court to challenge the DPP's certificate of bail denial. And another challenge that also arises in challenging the DPP's certificate of bail denial is the court in which the DPP's certificate of bail denial can be challenged. There are cases, economic cases are ordinarily triable by the High Court, the Corruption and Economic Crime Division of the High Court. So, if an application for bail is made in an economic case triable by Corruption and Economic Crime Division of the High Court, the question, if the DPP files the certificate of bail denial, then the question would be, can the accused challenge bail denial in the Corruption and Economic Crime Division of the High Court, which is competent to try the economic offense, or can he file it in the subordinate court? Can a subordinate court declare that the DPP's certificate of bail denial is malified? Is that jurisdiction given to the subordinate court? As we all know, courts derive their powers from the law. If there is no law conferring the court with power to give a certain order, then court cannot make such an order. There is no law, to my understanding, which gives a subordinate court power to declare DPP certificate of bail denial malified. In other words, I do not know law that gives a subordinate court power in economic cases to control DPP's abuse of power. Another challenge in challenging the DPP certificate of bail denial is what form can that complaint against the DPP certificate of bail denial take? Can it take a form of criminal application, or can it take a form of civil application? That is also not clearly, or was not clearly stated in the case of Symphony and Masawi. Now let's look into the trial process of economic offenses. Generally, all economic offenses are triable by the High Court. Subordinate courts can only try economic offenses if DPP files a certificate conferring a subordinate court with jurisdiction to try an economic offense. But the triability of economic offenses by the High Court is subject to value threshold for some of the offenses. There are offenses which are triable by Corruption and Economic Crime Division of the High Court, irrespective of the value of the offense involved, irrespective of the value of the property involved in the charge. But there are offenses that are triable by Corruption and Economic Crime Division of the High Court, subject to the value of the property involved in the charge. For example, unlawful possession of firearm is an economic offense. It is an offense triable by the High Court, the Corruption and Economic Crime Division of the High Court, irrespective of the value, because a gun or an ammunition ordinarily, when prosecutor charging unlawful possession of a firearm or an ammunition, he will not ordinarily put the value of the gun, because it is not the value of the gun that is in dispute. It is the possession of the gun which is in dispute. And therefore, the triability of the offense of unlawful possession of firearm or ammunition is not dependent on the value of the property involved in the offense charged, which is the gun. But the triability of the corruption offenses by Corruption and Economic Crime Division of the High Court is subject to or dependent on the value threshold. For the Corruption and Economic Crime Division of the High Court to try a corruption offense, such corruption of the value in the corruption offense should not be less than 1 billion shillings. If the value involved in the charge is less than 1 billion shillings, such offense has to be tried by a subordinate court. But a billion question is, will the DPP be required to issue a certificate conferring a subordinate court with jurisdiction to try a corruption offense if the value involved in the charge is less than 1 billion? The answer is yes. The answer is yes because subordinate court can only try an economic offense listed in the first schedule to the Economic and Organized Crime Control Act if such subordinate court is given power to try the economic offense by the DPP. Whether the value is less than 1 billion or not, a subordinate court can only try an economic offense or a corruption offense if the DPP issues a certificate conferring the subordinate court with jurisdiction to try any offense listed in the first schedule to the Economic and Organized Crime Control Act. Another important thing to note is even when the offense is triable by the High Court, the Corruption and Economic Crime Division of the High Court, the DPP must give consent to the Corruption and Economic Crime Division of the High Court to try an economic offense. So consent is a must, irrespective or regardless of whether the court trying the charge has jurisdiction under the law or not. So a consent is given and must be given by the DPP for any court to try an economic offense. But certificate is given to the subordinate court in addition to the consent for the subordinate court to have jurisdiction to try an economic offense. But if a charge is filed in the Corruption and Economic Crime Division, economic offense is charged in the Corruption and Economic Crime Division of the High Court, but such charge is mixed up with a non-economic offense, the DPP has to issue a certificate conferring jurisdiction on the Corruption and Economic Crime Division of the High Court to try a non-economic offense mixed up with the economic offense triable by the Corruption and Economic Crime Division of the High Court. Another important thing to understand is that at the time of enactment of the Economic and Organized Crime Control Act, the judge of the High Court was sitting with the 2 lay members. In the year 2016, the Economic and Organized Crime Control Act was amended by Act number 3 of 2016. And now a judge sitting in the Corruption and Economic Crime Division of the High Court is no longer required to sit with 2 lay members of the court. Equally, it is important to know that before the accused is tried by the Corruption and Economic Crime Division of the High Court, the case must start at a subordinate court where a holding charge is normally filed, and after the completion of investigation, the accused is committed to the High Court, the Corruption and Economic Crime Division of the High Court for trial. This is where there is a problem. In most cases, economic crime cases take too long in the subordinate court, awaiting committal of the offenders to the High Court for trial. Why is it take so long? The main reason is the law does not give the subordinate courts power to control delay of investigations of economic crime cases. Subordinate courts do not have power to make any adverse order against prosecution side for failure to complete investigation in time. The law, there are rules that were made by the Chief Justice under the Economic and Organized Crime Control Act that requires the Corruption and Economic Crime Division of the High Court to complete proceedings within 9 months from the date the accused is committed to the High Court for trial. But unfortunately, this control, the law does not give any control over delay or inordinate delay to commence prosecution against suspects or accused of economic crime cases. Now let's look into the effects of being charged with an economic offense. One of the effects of being charged with an economic offense is right to bail. As we have seen, once someone is charged with an economic offense, if the amount involved in the charge or the value of the property involved in the charge is 10 million or more, the accused has to petition for bail in the High Court. In other words, if you are charged with an economic offense and the value involved in the charge is 10 million, there is no way you can get bail on the same day you are brought before the court. You will have to stay in remand custody while your lawyer or yourself petitioning for bail to the High Court. So that one, it affects the right to bail. The second effect of being charged with an economic offense is that the magistrate will not have power over the case. The magistrate is given power by the DPP. So if the DPP doesn't give the magistrate power on the first day he files a holding charge in the magistrate's court, the magistrate will not be able to control the proceedings, particularly to control the delay of investigation. The other thing, or another effect of being charged with economic offense is the trial procedure. The trial procedure, once charged with an economic offense, the procedure for trying the offense charged should be in accordance with the Economic and Organized Crime Control Act. And we have seen that that denies the magistrate or the court, the magistrate court, power to control the proceedings. Another effect is the control over the proceedings, and even the nature of the sentence to be imposed will also change. Once charged with an economic offense, then the minimum sentence that the court may impose is 20 years imprisonment. Another thing which is taken away when charged with economic offense is compounding. There will be no compounding. The law does not allow compounding of an economic offense. Now, in short or in summary, charging someone with an economic offense is a very serious decision. There is a need for the prosecutors to look into their decisions of charging an economic offense, and it should be charged only when it is really necessary. But something to note, which cannot be even controlled by the prosecutors, the amendment of Economic and Organized Crime Control Act by Act number 3 of 2016 doubled the quantity or the number of the economic offenses in the first schedule to the Economic and Organized Crime Control Act. There is a need for the government to look into this again. The policymakers should look into this schedule again to see if there is really need to have all the offenses listed there as economic offenses. Some are really regulatory offenses or compliance offenses, which do not need to be there as economic offenses. So there is a need to look into it and keep only the offenses that really have the effect in the economy, and those offenses that really affect the security of our country. Thank you for listening.
Thank you, Vitalis. I apologize for going a little over time. However, I think you will all agree that that was quite informative and a brilliant presentation for all of you today. So Vitalis, are you still with us? Are you ready to take some questions?
Yes. I'm ready.
We have had We have had so many questions come in. We will do our best to try and get through as many as possible. I will start with a few, and we'll see how we're going. So thank you everyone for your patience. Okay, we'll start with the first question. Right. You said that the Director for Public Prosecutions can use a certificate to make a non-economic offence into an economic offence. I find that unreal. Has he ever used this power?
I know, I do not know, and I've not had any case where the DPP filed a certificate in the Corruption and Economic Crime Division to give the Corruption and Economic Crime Division of the High Court power to hear and finally determine a non-economic offense. But I personally prosecuted a case in the Corruption and Economic Crime Division of the High Court, where the accused was charged with both economic offenses and the non-economic offenses. And the DPP gave power to the Corruption and Economic Crime Division of the High Court to hear and finally determine both corruption, economic and the non-economic offenses.
Thank you, Vitalis. I'll move on to the second question. Lots of comments here of how wonderful the presentation was. And here we have one. Thank you for your wonderful presentation. My question is, it seems like almost all offenses are economic offenses. I find it hard to understand. Can you elaborate?
Yeah, it's really hard to understand what conduct will amount to an economic offense until you go back to the first schedule to the Economic and Organized Crime Control Act to check. Even if you are experienced prosecutor, even I, when I was still prosecuting, despite my long experience in prosecution, I had to go back to the first schedule to the Economic and Organized Crime Control Act before charging anyone with the offense to see if the offense I want to charge is listed in the first schedule or not. Because as I said, there are hundreds of conducts that amount to economic offense. So it's really confusing, and that's why in my last remark I was saying there is a need to relook into this if we really need all these conducts to be in the first schedule to the Economic and Organized Crime Control Act as economic crimes.
Thank you, Vitalis. We'll move on to the next question. If I heard you correctly, that for an economic offense, the minimum penalty is 20 years. However, some of these offenses are very minor. How can one be sentenced to 20 years for such simple offenses?
The sentence for economic offenses, for offenses listed in the first schedule to the Economic and Organized Crime Control Act, does not depend on the gravity or seriousness of the offense charged. Once it is listed, because court has no discretion to determine the sentence to be imposed depending on the seriousness of the offense, once it is an economic offense, there is only one sentence. The minimum sentence is 20 years imprisonment, regardless of the seriousness or the gravity of the offense committed. No voice. No voice.
Thank you for the brilliant presentation. You did a great job. You said that possession of goods suspected to have been stolen or unlawfully acquired, if they are valued at over 1 million shillings, is an economic offence. From what I know under the Penal Code, this offence has a sentence of maximum 3 years. Now, if the prosecutor chooses to take this as an economic offence, do I get sentenced to 20 years? Is this not too harsh?
It is too harsh, and that's why I was saying one of the effects of charging someone with economic offense is he will finally, if convicted, be sentenced to a very severe sentence of a minimum of 20 years imprisonment. But what I know, prosecutors really want to go for the maximum sentences or severe sentences. So when there are two laws, one law providing a severe sentence, another law provides a lenient sentence, prosecutor in most cases would wish to go for the law that prescribes a severe sentence. So it's true, if you are charged, if the accused is charged under the penal code and found guilty, you will be sentenced to a maximum of 3 years imprisonment. But for the same offense, if he's charged under the Economic and Organized Crime Control Act, he'll be sentenced to a minimum of 20 years imprisonment.
I'm sure that's not the answer you were looking to hear, but yes, the penalty is severe. Okay, the next question, let's see what's coming up on. Okay, great. I am confused. You said that economic offenses are bailable, but I was told that they were not bailable. Can you clarify?
The only 3 unbailable economic offenses: terrorism, money laundering, and drug trafficking. Those are unbailable economic offenses. The rest are bailable, but what I said is the bailability of the rest of the offenses also depends on some condition. The DPP may file a certificate denying bail for a bailable offense, but the accused may also be denied bail by the court for some days because of the threshold that you are charged with an offense and the amount or the value of the property involved in the charge is more than 10 million or more. So the magistrate on the first day of appearance before him or her will not admit the accused to bail, but will tell the accused, you may petition for bail to the High Court. And that may not take a day or two. It may take some days or some weeks or even a month.
Thank you, Vitalis. Your presentation was brilliant. Your 20 years experience in criminal law is also commendable. You said that this economic crime law is a 1984 law. I find it very strict and now time barred. Do you think there is a need to relook at this law and draft a new law?
Yeah, that is my thought, that there is a need to relook into this law and really see if it is consistent with the our constitution, particularly the Bills of Rights, which is part of our constitution. And also there is a need to relook into it if it causes over congestion of our prisons, or and what can we do really, because we are now told there are so many inmates in our prisons who are charged with economic offenses, and they are in because of the nature of the offenses they are charged with. So I think if we really reduce the number of the offenses we have in the first schedule to the Economic and Organized Crime Control Act, and retain the only few offenses that really qualify to be economic offenses, then we can even use that amendment or reform to decongest our prisons that are fully congested at the moment.
Let's hope that recommendation can be taken forward and implemented. Wouldn't that be great? You very briefly spoke about money laundering, but that is the other big issue that businessmen are always worried about. I know you have shortage of time, but can you briefly talk about money laundering?
Yeah, it's a wide subject, but what I can say, the money laundering legal framework in Tanzania is extremely wide. It's possible to charge many people with money laundering offenses. I'll give you an example of someone who steals a book or you steal someone's mobile phone. Stealing, theft of a mobile phone can be charged as money laundering. How can it be charged as money laundering? Because what you need, in Tanzania, the law allows or recognizes what we call self-laundering. You launder the property, the proceeds of you can launder the property which is a proceed of the crime you have committed yourself. So if someone steals a phone, stealing is a predicate offense. Phone is a property. And one of the things a prosecutor needs to prove in order to charge the offense of money laundering is possession. So how can someone steal a phone without possessing? So the moment you steal a phone, you commit a predicate offense. A phone is a property and it's a proceed of the theft you have committed, and you have to possess it because you cannot steal without possessing. And when you possess the proceeds of the crime you have committed yourself, you cannot say, I didn't know this is a proceed of a crime. So the knowledge is by implication that you were in possession of the stolen phone with the knowledge that the phone is stolen because you committed the offense yourself. That one will be enough to charge someone with money laundering. There is no need of proving disguisement. There is no need of proving maybe concealment. There's no need of proving all those things. It all depends on which provision that the prosecutor used to charge the offense. So prosecutor may decide to use section 12, subsection A or D. If prosecutor charges the offender under section 12A and the 12D of the Anti-Money Laundering Act, prosecutor will not be required to prove disguisement, concealment, or whatever of the illicit source of the property. So it's really simple to charge money laundering in Tanzania, and you can even charge someone selling charcoal with money laundering. You can even charge someone who has stolen a chicken with money laundering. It's extremely wide. It's prosecutor's discretion to decide whether he wants to charge money laundering or not. So in a nutshell, that's what I can say, but it's a very wide subject.
So I guess the advice is don't blame being ignorant then. Know your stuff and be careful. Okay, the next question. Is the mandatory sentence in an economic crime 20 years? Can you negotiate this sentence to be lower if you plead guilty? Is 20 years not very tough?
Well, we have seen negotiation or what we call plea bargaining in economic offenses, which really attract 20 years imprisonment. Luckily, it started without any law in place allowing negotiation, because if you look into section 60 sub 2 of the Economic and Organized Crime Control Act, it looks like there's no room for negotiating the sentence. There is no room. Even if you enter into a plea bargaining, the minimum sentence you will have to that the court will have to impose is 20 years imprisonment. But there are Chief Justice rules on plea bargaining, and the rules made by Chief Justice on plea bargaining allow parties, the accused and the prosecutor or a defense counsel with the prosecution side, to suggest what sentence do they propose for the court to impose. But the court is not bound by the suggestion, but at least it presupposes now that in a plea bargaining, then the magistrate or the judge can impose lower than the 20 years sentence, which is the minimum sentence for economic offenses.
Thank you, Vitalis. Thank you for your presentation, Advocate Vitalis. There was a case many years ago that you had prosecuted and that I attended as a student. Wow. I could see your skills in prosecution, and now we are happy that you are a defense counsel. My question, you said that when one is charged with an economic offense, the DPP can single-handedly decide that no bail should be given to you by filing a certificate. This gives the DPP too much power, does it not? If the DPP issues such a certificate, can it be challenged or appealed against?
Yes. Yes, as you could see in the legislative history, the legislature giving too much power to the executive to determine right to bail. Under the Economic Sabotage Act, power was given to the president to determine whether someone should be admitted to bail or not in economic sabotage crimes. And now you see under the Economic and Organized Crime Control Act, DPP is given power to determine whether someone should be admitted to bail or not by filing a certificate in court to deny bail. So it's what I can say is too much power because it is unchecked power. Although the Court of Appeal, in the case that I cited, Symphorian Masawi, the Court of Appeal was of the view that it can be challenged if it is made in bad faith, but still there is no clear procedure as to how someone can challenge that. What I have seen in the recent days is people going to the High Court sitting as a basic and a human right court to try to challenge the DPP's power. But mind you, when someone is challenging the DPP's power by way of a constitutional petition, that takes a civil form. The complication then is, how do you use the civil forum now to determine the charges that are in a criminal forum? Still, there is a complication there, using civil forum to determine the charges or powers of the DPP that are in a criminal forum. So there is a complication.
Thank you, Vitalis. Since we still have a few more questions coming in, we've decided to extend the time to respond to those questions. So for those of you who can stay on the webinar, please do. We will continue just a little bit more for the remaining of the questions that are coming in now. Does the Law of Marriage Act have any offences that can be economic offences? For example, adultery or anything similar?
Offenses, there are offenses under the Law of Marriage Act, but these offenses under the Law of Marriage Act are not listed in the first schedule to the Economic and Organized Crime Control Act. And for that reason, offenses under the Law of Marriage Act are not economic offenses because they're not listed in the first schedule.
Okay, great. If I am supplying medicine to hospitals, if I don't get paid and I stop supplying, is this an economic offense?
It's not listed. That offense is not listed in the first schedule to the Economic and Organized Crime Control Act. So if it's not listed there, then it's not an economic because it's not listed in the first schedule, despite maybe the effect that it has, it's not listed.
Okay, thank you. What is the difference between an economic offense and money laundering?
Difference between economic offense and money laundering. Money laundering is one of the economic offenses. So economic offense is a wide subject. There are hundreds of economic offenses, but money laundering is one of the economic offenses.
Okay. I was told the Court of Appeal had ruled that money laundering is now bailable. Is that true?
No, it has not been ruled that money laundering is now bailable. Money laundering is still unbailable.
My main concern is the 20 years imprisonment. Lots of questions on the 20 years. How can the law have a blanket 20 years for all kinds of economic offenses? I find it very unfair. Should there not be different years for different types of economic offenses?
That's what I was saying. There is a need to relook into this. Instead of having only one penalty for all the global penalty, for all the offenses, there is a need to relook into the seriousness of these offenses and give a room to the magistrate probably to, or the judge, to impose the sentence depending on the seriousness of it's unreasonable really if someone pretends to be a PCCB officer and then is sentenced to 20 years imprisonment, like a person who maybe has laundered 200 billion shillings. It's really what I guess it's unreasonable. You don't see any logic in it.
Okay, and just coming to the last question now. How often is the schedule to the Economic and Organized Crime Control Act changed? Can the number of offences be reduced, as it seems there are too many offences?
Yes, schedule according to Section 58, sub 2 of the Economic and Organized Crime Control Act, schedule to the Economic and Organized Crime Control Act can only be changed by an act of the parliament. So if there is a need to reduce or change the first schedule, then there must be an act of the parliament reducing or removing some of the offenses from the first schedule. So in adding, the minister can add with approval of the National Assembly. But when it comes to removing, it's the parliament that can remove some of the offenses from the first schedule to the Economic and Organized Crime Control Act.
Thank you. Last few comments. I don't have a question, but a comment. You seem to know all criminal laws by heart. I wish to congratulate you. Thank you. Lovely message. If I fail if I fail to pay a parking fee, is that an offence? Is it money laundering? Is it an economic offence?
It's a very good question. Failure to pay park fee may amount to loss of revenue, but in order to charge it as occasioning loss, which is an economic offense, it all depends on the nature of the victim. If the park authority is a private company, then the accused who fails to pay park fee cannot be charged with an economic offense. But if the authority that collects the park fees is a public authority and there is a failure to pay, the accused can be charged with occasioning loss and can be sentenced to 20 years imprisonment. So it's the nature of the company or the entity collecting the park fee that determine whether you can charge offense of occasioning loss to a specified authority under the law means public authorities, not private entities.
Right. Well, I think we have come to the end of today's webinar. Thank you, Vitalis, for an excellent presentation. We've seen from all the wonderful comments and questions that have come in that it has stirred quite some activity amongst the participants. So thank you so much. Just to let you know that we will have a follow-up webinar coming soon on economic crime. So do look out for an invite in your inbox. And we do plan to have webinars on other topics too. Once again, if you are not subscribed to our Q&A and legal updates, do visit our website, send us an email, sign up, and you'll start receiving our Q&A and our legal updates, which will keep you well informed of what's going on out there in the legal world. Thank you all for attending and your patience, and apologies for going over time again, but as you can see, we had a lot of questions coming in. Very interesting topic indeed. So thank you again. I will send the evaluation form out, so please take a few moments to fill that in and hopefully see you at the next webinar. Thank you and goodbye.